Merci et merci à tous. Je suis très content d'être ici aujourd'hui. Et merci pour votre invitation de partager quelques idées, mais je vais partager mes idées en anglais. Politesse à commencer. So we've had a lot of talk here about pursuing international criminal justice remedies. Earlier in the day, and Doreen has reiterated some of this. What I want to do is to talk about a different type of accountability or a different type of justice. And that's what international lawyers call accountability at the level of state responsibility. So this isn't a question of holding individuals criminally liable for their acts, but of holding the state itself accountable for violations of international law. And specifically, I want to talk about the possibility of a case being brought against Myanmar at the International Court of Justice. So that's the ICJ, or CIJ in French, not the ICC, although they are both located in The Hague. Let's see if this works. Yes. And I'm sorry, I can't believe I'm the only person who brought slides today. So unlike the ICC, which has a prosecutor and puts individuals on trial, the ICJ, which is the principal judicial organ of the United Nations, and sometimes called the World Court, hears disputes between sovereign states. So there are no individuals appearing before the ICJ, there are states. And the ICJ doesn't choose what cases to hear. It doesn't go out and find cases. It hears those disputes which are brought to it by states, and its judgments are final and binding. Now, it's important to understand that the jurisdiction at the ICJ is consent-based. So that means that at some point along the line, the states that are appearing before the ICJ to have their disputes resolved have to have consented in some way to the court's jurisdiction. And for example, sometimes states will have a dispute, an active dispute between them, and decide, we're going to enter into a special agreement, or compromis, to send that dispute to the court. So they consent to an existing dispute. But in other situations, consent is given in advance. For example, when a provision in a treaty states that the parties to that treaty agree that in the event of disputes arising in the future, they will consent to the ICJ's jurisdiction to hear that dispute. And that is the situation that we have with Myanmar. Myanmar is a party to the 1948 Convention on the Prevention and Punishment of Genocide. And Article 9 of that treaty provides that the parties consent, at the time they sign up to the treaty, to have their disputes about compliance with the Genocide Convention decided by the ICJ. Now, some states have taken what's called a reservation to this Article 9. And they've said, well, we will abide by the treaty, but we don't accept ICJ jurisdiction over Genocide Convention disputes. But importantly, Myanmar is not one of those states. There are about 15 out of the 149 states, I think, that are parties to the Genocide Convention. So Myanmar hasn't opted out. What does this mean? Yeah. That means that if any other state that's a party to the Genocide Convention has the right to bring a case against Myanmar at the ICJ to pursue the claim that Myanmar has failed to comply with its obligations under the Genocide Convention with respect to the Rohingya. Not to pursue claims about crimes against humanity or other human rights violations, but claims relating to genocide. And there's no requirement that the state bringing that case have been directly injured in some way. Oftentimes that is a requirement, but the particular nature of the Genocide Convention means that it would not apply here. So this option, an ICJ case, that option exists. We've heard a lot of talk today also about what do we do about the Security Council veto? How do we activate this? Will the ICC be able to meaningfully prosecute cases? Well, this other option does exist, and that's remarkable because in many situations the court doesn't have jurisdiction. Very few cases actually go to the ICJ. So what might a case at the ICJ actually hope to achieve? Above all, it would be a chance to seek judicial recognition for the idea that Myanmar bears international responsibility for genocidal acts against the Rohingya. And it would also be a means to seek various forms of material relief. And that could range from financial compensation to an order telling the government to enact various structural reforms aimed at restoring communities that have been destroyed and preventing future cycles of violence. And very importantly, and I think this goes to some points that Professor Packer has made in his earlier intervention, just bringing the case at the ICJ might be a way to put pressure on the government and to put pressure on third states that are supporting the government or doing business with the government, pressure that would be aimed at changing their policies and their practices. And finally, if you bring a case at the ICJ, that creates the possibility for seeking what are called provisional measures. So these are a kind of emergency mechanism designed to obtain interim relief while the case is pending. And that's important because, like the case at the ICC, a case at the ICJ takes a long time. If you filed an application at the ICJ tomorrow, you would easily be looking at 4 or 5 years before you got a judgment. Because there are various phases that the case has to go through and so forth. So my point here is that you could nonetheless file an application and then seek provisional measures to get some kind of interim relief in the meantime while that case is pending. Now, despite the fact that there's jurisdiction to sue Myanmar at the ICJ, there are serious obstacles to doing this and getting a successful outcome. And just because a case could be brought at the ICJ doesn't mean that it should be brought. So let me make 3 points about this. First, to bring a case at the ICJ, you need to find a state willing to bring it. States don't bring cases lightly at the ICJ, and they shouldn't. It's a serious undertaking. And it's rare, not unprecedented, but rare, to find a state that hasn't itself been directly injured in some way to bring a case. Bringing an ICJ case can have political costs, it can have economic costs. It would likely be perceived as a hostile act by Myanmar, and perhaps by states that are close supporters of the government. So there's a serious question: what state, or maybe states, would be willing and able to undertake such a litigation? Because that requires a commitment to provide the necessary resources and a commitment to deal with the political blowback that might follow. So I don't have an answer for this. I don't know what state might be willing to do so. Is it France? Is it Canada? Is it Ireland, where we have a vibrant community of Rohingya refugees in County Carlow, where I'm based? I don't know. But I think that's a discussion that people should be having, because I've been amazed that in all the discussion about seeking accountability and justice for the Rohingya, the focus has almost exclusively, it seems to me, been on international criminal justice rather than this other mechanism that exists. My second point, and this is also very important, and it might be disappointing to people in this room, but there is a serious question about whether a claim alleging genocide against Myanmar at the ICJ would succeed as a legal matter. Now, given what we know about government policies and 30 or 40 or more years of discriminatory practices, and all the overwhelming evidence of terrible atrocities that have taken place over the last 5 or 6 years, this might be surprising to you, but I think it would be irresponsible for me to suggest otherwise, to suggest that this would be a sure thing at the ICJ. Many of us, whether we're journalists or politicians or activists or academics, tend to use the term genocide in our day-to-day speech in a way that is different from what that term actually means and requires as a legal matter, whether we like it or not. And sometimes that events that look like genocide, or what we think surely should be genocide, as a legal matter, they might be more accurately characterized as crimes against humanity, which is a broader category of mass atrocity that, while not easy to prove, is in essence easier to prove than genocide. And I should be clear that calling something a crime against humanity shouldn't in any way be seen as diminishing the gravity of what's taken place. But there's a pretty big legal distinction between the two. That said, I understand, and I've had conversations with Tsarni about this, that when something can be described as a genocide, it takes on an additional political resonance that might be more likely to provoke a serious international response. I can't get into the details here, but maybe in the Q&A, I think it's fair to say that the law of genocide has been interpreted by international courts and tribunals, and by that I mean both the ICJ and the ad hoc criminal tribunals for Yugoslavia and Rwanda. The law of genocide and the convention has been interpreted over time in a highly restrictive way. So even when there's abundant evidence of terrible acts, violence, cruelty, this task of demonstrating the required genocidal intent this intent to destroy in whole or in part a protected group is very steep. So the enthusiasm that maybe you have, or maybe I have, for an ICJ case has to be tempered by this very real possibility that a genocide claim might not succeed as a legal matter. That doesn't necessarily mean that bringing a case wouldn't have political value or other uses, but we have to keep that in mind. And it gets to my third point, which is that we have to weigh the potential benefits of an ICJ case against the costs. One benefit of bringing a case, as I said, is that it would force Myanmar, if they showed up, to address these claims in a formal judicial setting, and that can have a certain effect. And although the claims would need to be about genocide and the Genocide Convention, the proceedings themselves would really be an opportunity to shine a light on everything that's happened, including the government's efforts to rewrite history and so forth. But that has to be weighed against the risk of the court finding that a genocide hasn't happened or the legal test hasn't been met, and the potential propaganda value of that result for the government. Secondly, as I said, bringing a case, and especially if you were able to get a positive judgment, this could put pressure on Myanmar, could put pressure on third states, could put pressure on businesses that are working in Myanmar. But, and I'm not really in a position to say whether that's a realistic hope, how much pressure it would actually put on the regime. But more problematic is the fact that there's a risk that bringing a case alleging genocide could have the opposite effect. That it might marginalize people within the regime, if such people exist, who negotiators can work with. It might embolden hardliners. It might frustrate or complicate whatever diplomatic initiatives might be underway, whether that means the framework that was proposed by Kofi Annan's advisory commission or something else. And worst of all is the fear that bringing an ICJ case might provoke the regime and lead to some kind of escalation in violence, and that it could become an obstacle, and further obstacle, to providing the humanitarian relief that's so desperately needed. These things are incredibly difficult to predict, and that's why I think people with relevant country-specific experience, expertise, and knowledge, whether that means people who are working on the ground, but also UN officials and foreign ministry officials engaged with Myanmar, need to be engaged on those types of questions if there's serious interest in pursuing an ICJ case. I just want to conclude, mindful of the time, with another idea that has been floated, which is this possibility of an alternative path to the ICJ, which is to seek an advisory opinion proceeding. Because in addition to hearing disputes between cases, that's one of the court's functions, it also has the power to issue non-binding advisory opinions on legal questions posed by certain UN bodies, like the UN General Assembly. And so if no state could be found that is willing to bring a case directly against Myanmar, there is the option of trying to lobby within the General Assembly to seek an advisory opinion request. And in that case, the question posed might look something like what I put on the slide here. Does Myanmar bear international responsibility for acts of genocide or crimes against humanity? Because you wouldn't be limited to genocide anymore if you went this route. And if so, what are the legal consequences? Or it could even be more specific. What are the legal consequences for third states and private entities if you want to try to get at this interest-based approach? I can't speak to whether it would be easier to get a majority in the General Assembly to take this step as opposed to finding one state to bring a contentious case. And I have some concern that China's influence in particular might make this a tough road. And I also have certain general reservations about this idea. First, unlike a judgment in a contentious case between two states, an advisory opinion is non-binding. It can't in itself order relief. It's framed as advice to the requesting entity, so it would be advice to the General Assembly. And secondly, I think the procedures around advisory opinions are not especially favorable to the painstaking, highly detailed task of proving claims related to mass atrocities. So even in an advisory opinion proceeding, any state can participate. They can make written submissions, they can appear in oral hearings in front of the court. That could be a mess, and you could cause real coordination problems. Ultimately, you still need really a single state, or maybe two states working closely together to organize, to compile that evidence, organize it, and present it in a compelling way to overcome some of the obstacles to proving genocide that the court has already thrown up. And third, this is something that international lawyers might debate among themselves. I have some concerns that this type of advisory opinion request isn't really in keeping with the intended function of the advisory opinion mechanism. Now you could say, well, you know, law can be instrumentalized. If there's a way to use it, let's use it. Maybe I'm a former employee of the ICJ. I'm obviously not here speaking on the court's behalf, but maybe I have a certain predisposition towards how I think the court is meant to run, and I have some discomfort with this idea of this type of use of the advisory opinion function, and I fear that there would be pushback within and beyond the court to trying to approach it in that way. But it's an option, and what I wanted to accomplish through this intervention is to lay out these two options, focused around the ICJ that haven't really seemed to percolate up very much in these discussions about what can we do, what can the international community do, what can people at an individual level do to try to make some kind of difference here. So because I have those concerns about the advisory opinion proceeding, my view is that a case brought by a single state against Myanmar at the ICJ would hold more promise and have the potential to serve as a focal point, or at least one useful element within a broader strategy of trying to protect, promote, and vindicate the rights of the Rohingya. Thank you.